On the 21st of February, 1753, a court in London sentenced a woman to hang for stealing 10 shillings worth of underwear. The underwear belonged to a servant girl named Elizabeth Canning. Canning was 18 years old. 4 weeks earlier, she had vanished from a street outside her uncle's house, and for 28 days not one person in London knew whether she was alive. When she came back, she was starved, she was bleeding, and she could barely stand. She told a story about a locked room and a woman with a knife. That story sent someone to the gallows. It is the reason a stranger was condemned to death for theft, in a country where kidnapping a grown woman was not, on its own, a crime at all. Nobody has ever agreed on whether a word of it was true, not her own lawyer, not the Lord Mayor of London, who investigated the case himself and staked his career on the answer, not the judges who tried this story twice, a year apart, in 2 different courtrooms, for 2 entirely different crimes. The first time, Elizabeth Canning was the witness. The second time, she was the defendant. This is the story of both trials, and of the question that 270 years of historians, lawyers, and readers have never been able to close. Not whether she was believed by half of London, passionately, for months. The question is whether she was telling the truth. Keep that question in front of you. Every fact in the next 2 hours will try to answer it, and every fact will fail. London, on the 1st of January, 1753, was a city that ran on servants. There were roughly 700,000 people living in and around it, and a very large share of them, women especially, worked inside someone else's house. They cooked in other people's kitchens. They carried other people's water. They slept in other people's attics. And they went where their employers told them to go. A servant girl belonged to no family of her own once she left home. She belonged, for the length of her contract, to whoever paid her wages. Elizabeth Canning was one of those girls. Her family had no property, no land, and no income beyond what its members could individually earn, which is why she had gone into domestic service young, the way most girls of her class did, because there was no other way to eat. She had spent time in the household of a publican named John Wintlebury, before moving, by the autumn of 1752, into the service of a carpenter named Edward Lyon, where she was still employed when this story begins. A surviving newspaper description of her, printed once her disappearance became public, gives a rare, specific physical portrait most servant girls of the period never received. Fresh-colored, it read, pitted with the smallpox, high forehead, light eyebrows, about 5 foot high, well set. It is an ordinary description, the kind that could have matched hundreds of working girls in London that winter. And that is precisely the point. Nothing about Elizabeth Canning, on paper, marked her out as someone whose disappearance would consume an entire city for 2 years. None of that background made her remarkable. Thousands of girls in London could have told the same biography, word for word, with different names filled in. What makes Elizabeth Canning's story worth 2 hours of your attention is not who she was before the 1st of January. It is what the legal system of Georgian England was prepared to do, on her word alone, to the people she named after it. On New Year's Day, she asked for time off to visit her uncle and aunt, Thomas and Alice Cawley, who lived near Saltpetre Bank, in the crowded lanes east of the city proper, not far from Houndsditch. It was an ordinary family visit, the kind any servant girl with a half-day's liberty might make, walking through streets she almost certainly knew well, past the same shop fronts and the same church towers she had passed 100 times before. She spent the day with the Cawleys. In the evening, as the light failed, she said her goodbyes and started the walk home, north and west, back toward Aldermanbury Postern, where her mother kept house. London, after dark in January, was not a gentle place for a young woman walking alone. The streets she would have crossed, Bishopsgate, the edge of Moorfields, the narrow lanes threading toward the Guildhall, were unlit except by the scattered light from tavern windows and the occasional link boy carrying a torch for a fee most servants could not afford. It was, by any account, an entirely plausible route for something to go wrong on. Whether something did, and what exactly that something was, is the question this entire case would spend the next 2 years trying and failing to answer. She never arrived. Her mother waited that night, and the next day, and the day after that. There was no letter, no message sent by a neighbor. No word passed along the way servants and shopkeepers passed word along in a city that size. Elizabeth Canning had simply stopped existing, somewhere on the walk between one relative's house and her mother's door, and nobody in London could say where. Aldermanbury Postern, where Elizabeth Canning's mother kept her small household, sat close against the old city wall, near the Guildhall itself, the administrative heart of London's civic government. It was a working, crowded neighborhood, not a fashionable one, home to the kind of families, tradespeople, small shopkeepers, and servants like the Cannings, who kept the city's daily machinery running without ever appearing in its more celebrated social circles. That geography matters, because it placed Elizabeth Canning's disappearance and eventual return within easy walking distance, both physically and socially, of the very civic institutions that would spend the next 2 years fighting over her case. The Guildhall, seat of London's municipal government, and the office Sir Crisp Gascoyne would occupy as Lord Mayor, stood close enough to Aldermanbury Postern that news of a servant girl's dramatic reappearance would have reached the ears of London's governing class within hours, not days. This was never a story confined to one poor family's private grief. From the very first night, it was unfolding inside the same small radius of streets where the city's actual power resided, which goes some way toward explaining how quickly it escalated from a family emergency into a matter engaging magistrates, aldermen, and eventually the Lord Mayor himself. Before we get to what Elizabeth Canning said happened to her, it is worth understanding exactly why a story about a kidnapped servant girl was so instantly, viscerally believable to the London of 1753. This was a city with a genuine, well-documented fear running underneath its everyday life. The fear of what contemporaries sometimes called spiriting, the abduction of young people, servant girls especially, for purposes ranging from forced labor in the colonies to, in the darkest and most whispered version of the fear, forced entry into prostitution. It was not a paranoid fantasy invented out of nothing. London in this period genuinely did contain networks that trafficked in exactly this kind of exploitation, preying specifically on young women with no family close by to notice quickly if they disappeared, no independent income to fall back on, and no institutional protection beyond whatever goodwill their employer happened to extend them. A servant girl who vanished from the street was not, to the Londoners hearing about it in early 1753, an abstract statistic. She was a specific, culturally loaded nightmare, the thing every mother of a working daughter quietly worried about every single time that daughter walked home after dark. When Elizabeth Canning's mother sat with neighbors during those 28 silent days, she was not simply hoping for the best. She was almost certainly running through, in her head, every version of the worst that London already knew how to imagine. This matters enormously for what happens next, because it means Canning did not have to convince her first audience, her mother, her neighbors, the crowd gathering in that room on the night of the 29th of January, that something like this was possible. They already believed it was possible. What she had to do was fill in the specific shape of a horror they were already primed, culturally and emotionally, to expect. That is not, on its own, evidence that her account was false. Real horrors happen to real people, inside cultures that are already afraid of exactly that horror, all the time. But it is essential context for understanding why her story moved as fast and as far as it did, converting an entire city to her side within days rather than months. She was not asking Georgian London to imagine something new. She was confirming something it had been quietly dreading all along. Understand what a missing 18-year-old servant girl actually meant, in the practical terms of 1753 London, because it is not what it would mean today. There was no police force in the modern sense. There was no organized system for reporting a missing person and setting professionals to search for her. What existed instead was a patchwork of parish constables, a handful of London magistrates who took on investigative work more or less as a personal project, and word of mouth spread through markets, taverns, and church doors, carried by whoever happened to know whoever was missing. For a family like Canning's, that meant the search for Elizabeth was, in practice, her mother's search. Her mother went to neighbors. She went to the constables. She put up notices, likely including the physical description already quoted: fresh-colored, pitted with the smallpox, high forehead, light eyebrows, 5 foot high, well set, the only tool available to turn one missing face into something the wider city might recognize on sight. And she waited, because there was very little else a poor widow in London could do to force a city of 700,000 people to look for one girl. That widowhood is itself part of the record worth stating plainly. Elizabeth Canning's father, a sawyer named William Canning, had died 2 years earlier, in 1751, leaving his widow to raise the family alone on whatever work she and her children could bring in. Elizabeth had been born in September of 1734, which made her 18 years old at the time of her disappearance, though some contemporary accounts give her age as 17, a small discrepancy that is itself typical of how imprecisely a poor family's vital records were kept in this period. What matters for this story is not the exact number, but the position it describes. A fatherless household, a widow with no independent income, and a daughter sent into service young because the family's economic survival required it. It is worth pausing on what Elizabeth Canning owned, and did not own, because it becomes important later. She had no property of her own. She had no independent income beyond her wages, which for a servant girl of her position would have amounted to perhaps £2 or £3 a year, paid out slowly and often held back in part until the end of a term of service. Whatever she wore on her body, and whatever small possessions traveled with her from household to household, essentially constituted her entire material existence. A servant's stays, the stiffened undergarment worn beneath a dress to shape and support the torso, were not a small purchase. A decent pair could run to 10 shillings or more, which for a girl earning £2 or £3 a year was a genuinely significant sum, something close to 2 full months of wages concentrated into a single garment. It was, in a very real sense, one of the largest single objects of value Elizabeth Canning owned, possibly the largest. Keep that number in your head. 10 shillings. It is going to reappear, and when it does, It will be doing work no clothing has ever done in an English courtroom before or since. For 28 days, that 10-shilling object, and the girl who owned it, simply disappeared from the record. No sightings that anyone could later confirm. No ransom demand. No body. London went about its business, the way cities do, and a servant girl's disappearance, however alarming to her family, was not the kind of event that stopped traffic in the streets. It was one missing girl among many, in a century when girls like her vanished into workhouses, into the river, into ships bound for the colonies, into 100 quiet catastrophes that never made it into any newspaper at all. Elizabeth Canning was about to make sure hers did. On the 29th of January, 1753, 28 days after she vanished, Elizabeth Canning appeared at her mother's door in Aldermanbury Postern. She did not appear the way a girl returning from a long visit appears. Witnesses in the house that night, and the neighbors who were called in within minutes, described her as barely able to stand. Her clothes were in rags. She was filthy and thin in a way that frightened the people looking at her, the specific, visible thinness of someone who has not eaten properly in weeks. There was blood on her. Her ears, by more than one account, appeared to have been recently pierced or torn, and there was a mark, a cut, around her neck. Henry Fielding, who would examine her formally within days, later described her condition in language that has survived almost word for word. Almost starved to death, he wrote, so like a specter that her mother fainted away when she saw her. Her limbs, he added, were all emaciated. Her mother, by every surviving account, nearly collapsed at the sight of her. For the first hours, Elizabeth Canning could barely speak. What she did manage to say, in fragments, to the small crowd of family and neighbors gathering around her, was this: she had been seized on the road home from her uncle's house on New Year's night. 2 men had grabbed her, robbed her of a small amount of money and her hat, and struck her hard enough to leave her half senseless. They had then dragged or carried her a long way, she could not say exactly how far or in what direction, to a house she did not recognize. Inside that house, she said, an old woman had cut the laces of her stays and taken the garment off her body, threatening her with a knife if she did not go along with it. She was then pushed up into a hayloft, above what she believed was a kitchen, and left there. For the next 28 days, she said, she survived on a small amount of bread, roughly a quartern loaf's worth in total, and water from a single black pitcher that was never quite full, with nothing else to eat, and no company at all except her own thoughts, and, twice, a brief and frightening visit from the old woman who had robbed her. She would later describe the room itself in specific terms. A fireplace and a grate, she said, though no bed or bedstead, nothing but hay to lie upon. When investigators asked her, much later, why she had waited as long as she had before attempting to escape, her answer was simple. Because I thought they might let me out, she said. It never came into my head till that morning. On the morning of the 29th, she said, she found a way to break out of the room, through a boarded window, and simply walked. She did not know the road. She did not know how far she had come. She knew only that she had kept walking, in the cold, in rags, until she recognized a landmark close enough to home to bring her the rest of the way on instinct. That was the account. A kidnapping, a theft, a hayloft, 28 days. Nobody in that room on the night of the 29th of January had any way to check a single detail of it. What they had was a starving, bleeding 18-year-old girl standing in front of them telling a story that explained completely and horrifyingly everything that had happened to her body while she was gone. They believed her. Almost everyone who heard that story in the first days believed her completely. The question London would spend the next 18 months tearing itself apart over was whether they were right to. One detail is worth sitting with before this story moves into the courtroom. The two men Elizabeth Canning said grabbed her on the road out of Saltpetre Bank on New Year's night were never identified, never charged, and effectively vanish from the entire rest of the case. Every subsequent proceeding, every trial, every pamphlet in the 2-year public war that followed, concerned itself almost exclusively with the house at Enfield Wash, with Mary Squires and Susanna Wells, and with the theft of a corset. The original violence Canning described, the blow to the head, the two unnamed men who allegedly seized her in the street, simply drops out of the historical record, unexplored and unresolved, because the legal system had no real mechanism for pursuing it, and, perhaps more tellingly, no real appetite to. If you are finding this case as strange and as maddening as the people who lived through it clearly did, that is exactly the point of telling it. Subscribe if you want more of these buried, evidence-heavy cases, the ones where the record is complete enough to argue about, but never complete enough to resolve. We will sit with this one a while longer, because it only gets stranger from here. Word moves fast in a city that runs on gossip, and word of Elizabeth Canning's return moved faster than most. Within 2 days, on the 31st of January, she was giving a formal account to a London magistrate, Alderman Thomas Chitty, the first time her story was taken down in any kind of official record. She repeated, in essence, what she had told her mother and neighbors on the night of her return: a kidnapping, a robbery of her stays, a hayloft, a door or a window forced open on the morning of her escape. Chitty's notes from that examination would later become a small but significant point of contention in their own right, when investigators, comparing them against the physical scene at Enfield Wash, found details that did not quite line up. On the 1st of February, a small group set out from the neighborhood, led by a tradesman named Robert Scarrett, to try to physically locate the house Canning had described. This was not, it is worth being clear, a professional police investigation, with trained detectives working a case. It was closer to a posse, a group of interested locals following whatever clues a traumatized 18-year-old could give them, in a city with no street numbering system anyone could rely on, and no records that would let them cross-reference her description against any actual property. And yet they found a house, out at Enfield Wash, a semi-rural stretch north of the city proper. They came upon a property kept by a woman named Susanna Wells, commonly known in the neighborhood by the informal title Mother Wells. Living there, or at least present there, was an elderly woman named Mary Squires, along with 2 of her adult children, a son named George and a daughter named Lucy, and a number of other residents and visitors who came and went from the house, among them a young woman named Virtue Hall, whose own testimony would soon become one of the most contested pieces of evidence in the entire case. When Canning herself was eventually brought to look at the property, she identified it, by her own account and the accounts of those present, as the house where she had been held. She identified Mary Squires as the woman who had cut off her stays. She identified the hayloft. Within a single week, then, of a starving girl reappearing at her mother's door with no evidence beyond her own testimony, the machinery of an accusation was already fully assembled. A named house, a named woman, a specific alleged crime, with a specific shilling value attached to the stolen object. And a magistrate, soon to be a much more famous one than Alderman Chitty, about to put his own considerable reputation behind believing every word of it. That magistrate's name was Henry Fielding, and what he did next would turn a servant girl's private catastrophe into one of the most explosive public disputes 18th century England ever produced. Here is the fact this case never lets go of, and it is worth restating before we go any further. In 1753, kidnapping a grown woman was not a crime under English law. Stealing her clothing was a hanging offense. Everything that happens next happens inside that gap. Henry Fielding was not an ordinary magistrate. By 1753, he was already one of the most famous writers in England, the author of Joseph Andrews and, 4 years earlier, of Tom Jones, a novel that had made him a genuine literary celebrity. He was also, alongside his half-brother John, doing serious, largely unpaid work, trying to build something London did not really have yet, an organized system for investigating crime, out of his post as a magistrate at Bow Street. He is remembered today as one of the founding figures behind what would eventually become the Bow Street Runners. On the 7th of February, 1753, Elizabeth Canning came before him and swore a formal deposition, the most detailed account of her ordeal that exists in the historical record. Under oath, in front of a magistrate whose entire professional reputation rested on his judgment of witnesses, she laid out the story again. The two men on the road, the blow to the head, the house she did not recognize, the old woman with the knife who cut away her stays, the hayloft, the bread, the water, the 28 days, the escape through a window. Fielding believed her immediately, and he believed her completely. He would later publish a pamphlet defending her, calling her, in his own words, a virtuous, modest, sober, well-disposed girl, and describing her demeanor to him personally as that of a child in years, and yet more so in understanding, with all the evident marks of simplicity he had ever discovered in a human face. Writing about her condition on the night of her return, he described her as almost starved to death, so like a specter that her own mother fainted at the sight of her. This was not a small thing. Henry Fielding's endorsement carried real weight in London. He was not a credulous provincial magistrate easily fooled by a sympathetic face. He was a trained legal mind and a professional judge of testimony, and he staked a portion of his own public standing on the claim that Elizabeth Canning was telling the truth. He was, within a year, going to look, to a great many people, catastrophically wrong. To understand why Henry Fielding's belief in Elizabeth Canning carried the weight it did, it helps to understand exactly what kind of career he had built by the time she walked into his office. Fielding had come to the law relatively late, after establishing himself first as a playwright and then, decisively, as a novelist. Joseph Andrews, published in 1742, and Tom Jones, published in 1749, had made him one of the most widely read authors in England, admired for exactly the quality that made his endorsement of Canning so consequential, an unusually sharp, worldly eye for human character and motive. This was not a man easily mistaken for a naive small-town magistrate. He had spent his professional life studying, dissecting, and writing convincing fictional portraits of liars, schemers, and self-deceivers. His readers trusted his judgment of people because his novels had already demonstrated, at enormous length, how well he understood them. By the time Canning came before him, Fielding was also doing something genuinely new for London, working with his half-brother John to build the beginnings of an organized, professional approach to criminal investigation out of the Bow Street Magistrate's office, an early and important step toward what would eventually be remembered as the Bow Street Runners. He was, in other words, actively trying to raise the standard of how London handled exactly this kind of case. Testimony taken seriously, investigated systematically, weighed by trained judgment rather than mob instinct. That context makes his conclusion about Canning Land very differently than if some anonymous, undistinguished parish official had simply taken her word for it. When Fielding wrote that she struck him as a virtuous, modest, sober, well-disposed girl, with all the evident marks of simplicity he had ever discovered in a human countenance, he was staking the judgment of a man whose entire reputation, both literary and professional, rested on his claimed ability to read people correctly. It is also worth noting, because it will matter later, that Fielding's private correspondence at points struck a slightly more guarded tone than his public pamphlet. He is recorded, through later accounts drawing on his own papers, describing her as one of the simplest girls he had ever encountered, adding, almost as a hedge against his own certainty, that if she was in fact a wicked one, she had been too hard for him to detect it. Even the man who believed her most completely, in other words, appears to have left himself a small, private door open to the possibility that he was wrong. The house at Enfield Wash belonged, in the practical sense of who ran it day to day, to a woman named Susanna Wells, generally called Mother Wells by her neighbors. It was, by most contemporary descriptions, not a respectable address. It had a reputation locally as the kind of place where all sorts of people came and went, and where questions were not always asked about who was staying under the roof or why. Living there at the time, among others, was Mary Squires, an elderly Romani woman. Contemporary accounts of Squires are, without exception, unkind about her appearance, several going out of their way to describe her as remarkably ugly, in language that says at least as much about the prejudices of the writers as it does about Squires herself. She traveled with several of her adult children, including a son named George and a daughter named Lucy, and the family appear to have made a living, at least in part, the way many Romani families of the period were forced to, by both custom and by a legal system that offered them almost no other option, through itinerant trading, fortune-telling, and casual labor as they moved through the countryside. It is worth being direct about something here. England in the 1750s had a long and genuinely ugly legal history, with Romani people specifically. Statutes going back more than 2 centuries had criminalized simply being identified as a gypsy, in certain circumstances, and the casual prejudice of the era treated Romani identity itself as something close to inherent criminality. Contemporary press coverage of this very case rarely bothered to use Mary Squires' name at all. Most reporting simply called her the gypsy, as though that were sufficient identification for a woman on trial for her life. That prejudice matters enormously to what happens next, because it shaped, from the very first day, how believable Squires' denials were ever going to sound to a London jury, regardless of what the actual evidence said. When Canning was brought to the property, she identified the house. She identified Squires as the woman who had robbed her of her stays, and she identified a specific hayloft as the room where she had been confined. Susanna Wells denied ever having seen Elizabeth Canning in her life. Mary Squires denied it just as flatly. Neither denial appears to have carried much weight against the word of a girl who had walked out of a month-long ordeal looking, by every account, exactly like someone who had lived through one. Mary Squires did not stand entirely alone in her defense, even at the rushed first trial in February of 1753. Her son George and her daughter Lucy both gave testimony regarding the family's movements and whereabouts, an early, if underdeveloped, version of the alibi that would eventually grow into the sprawling, dozens-strong Dorset case presented at Canning's own trial a year later. A third son, John Squires, is named in some contemporary accounts as a suspected accomplice in the alleged original abduction, though he was never formally charged and appears to have avoided arrest entirely, another loose thread the case never manages to tie off. What this early, thinner version of the family's testimony lacked, in February of 1753, was time. Gascoyne's later investigation had the luxury of an entire year to track down witnesses across Dorset and Wiltshire, to gather affidavits, to build a case methodically. Squires's own children, testifying within weeks of her arrest, had none of that. They could offer their word, and little else, against a court already moving at the rapid, single-day pace that had convicted her before anyone outside her immediate family had time to organize a real defense. Here is the fact that the entire case turns on, and it is worth stating plainly because it explains almost every strange decision that follows. In 1753, under English law, kidnapping an adult woman was not, on its own, a felony that could be prosecuted with any real severity. There was no statute that treated the forcible seizure and imprisonment of a grown person as a capital crime, or in many cases as a serious crime at all, in the way modern law would understand abduction. It existed, legally, in something close to a gap. Theft, on the other hand, was treated with extraordinary severity. English criminal law of the period, later given the grim nickname the Bloody Code by historians, extended the death penalty to an enormous range of property crimes, many of them involving what would today seem like shockingly small sums of money. Grand larceny, theft above a certain fixed value, routinely carried a sentence of death by hanging, regardless of whether any violence was involved in the taking. This meant that if Elizabeth Canning's account was true and two people had genuinely seized her, held her captive for 28 days, and terrorized her, the law of England offered almost no direct mechanism to punish that as its own crime. What the law could punish, decisively and fatally, was the theft of her stays, valued at roughly 10 shillings, an amount comfortably above the threshold that turned larceny into a hanging offense. So that is what went to trial, not kidnapping, not false imprisonment, not assault. A charge of grand larceny for stealing a corset because the law simply had no other tool sharp enough to use. Sit with that for a moment, because it is the thesis this entire case rests on. A legal system that would execute a woman for stealing 10 shillings worth of clothing had, at the very same moment, almost nothing to say about someone allegedly locking an 18-year-old girl in a room for a month. The law protected property with the full weight of the gallows. It protected people, especially poor people, especially women, with considerably less. Mary Squires was not, in the end, on trial for what Elizabeth Canning said had been done to her body, her freedom, or her safety. She was on trial for the corset. The gap in English law that sent Mary Squires to trial for theft rather than kidnapping was not an isolated oddity. It sat inside a much larger, much stranger structure of criminal law that historians would later give a grim, informal name: the Bloody Code. By the middle of the 18th century, English statute law extended the death penalty to well over 100 distinct offenses, a number that would keep climbing for decades to come, eventually reaching past 200 by the early 1800s, before major reform finally began stripping it back. Many of these capital offenses involved property crimes that, on their face, look startlingly minor to modern eyes. Stealing goods above a certain value from a shop, damaging a fish pond, cutting down a young tree in an orchard or garden, being found disguised in a forest at night, under certain vagrancy statutes originally aimed at poachers, impersonating a Chelsea pensioner to collect a pension not owed to you. Against that backdrop, a charge of grand larceny for stealing a 10-shilling pair of stays was not, in the context of 1753 England, an unusually severe or unusual use of the law. It was simply one more entry in an enormous catalogue of property offenses. The state had decided merited death, a catalogue built up, piece by piece, over decades, largely at the insistence of property owners and merchants who wanted the harshest possible deterrent against theft, with comparatively little corresponding urgency applied to crimes against a poor person's body or freedom. This is where the case intersects with an older, even uglier legal history, the treatment of Romani people under English law. Statutes dating back to the 1530s, beginning with an act passed in the reign of Henry VIII, sometimes referred to as the Egyptians Act, had criminalized Romani identity itself in certain circumstances, mandating expulsion, and under later reinforcing statutes, treating the simple fact of being identified as what the law called a counterfeit Egyptian as grounds for punishment that could, in some formulations across the following 2 centuries, extend to death. By the time of Mary Squiers's trial, this deep legal and cultural hostility toward Romani people had softened somewhat, in strict statutory terms, but it remained very much alive in the ordinary prejudice of the courtroom and the press, where Squires was overwhelmingly referred to simply as the gypsy, rather than by her own name. Put these 2 threads together, and the shape of Mary Squiers's trial becomes considerably harder to separate from the specific woman standing in the dock. A legal system already primed to punish property crime with maximal severity, applied to a defendant already marked by centuries of specific, targeted legal and cultural hostility toward people of her ethnicity. Whatever the truth of what happened to Elizabeth Canning in January of 1753, the machinery that convicted Mary Squires for it was not operating on a neutral field. To make the bloody code less abstract, it helps to sit with a handful of the specific offenses it covered, because the list reads, to modern ears, almost like satire, except that every entry on it was genuinely enforced and genuinely carried a death sentence. Stealing property worth more than a shilling from a person's body, the exact category of offense applied to Mary Squires, sat on the same statute books as poaching a rabbit from a private warren, sending a threatening letter demanding money, and impersonating an army pensioner to draw a payment that was not owed. A child as young as 7 could, in strict legal theory, be held criminally responsible under this system, though courts of the period exercised some, though by no means total, discretion in how young offenders were actually sentenced. Judges and juries did have tools available to soften the system's harshest edges, most notably benefit of clergy, the mechanism that spared Susanna Wells the noose in favor of branding, and the royal pardon power that ultimately saved Mary Squires herself. But those were exceptions granted case by case, at the discretion of individual officials, not a structural feature of the law itself. The law's default setting, for a huge range of property offenses was death. Set beside that catalog, the near total absence of any equivalent statute punishing the forcible seizure and imprisonment of an adult woman looks less like an unfortunate gap and more like a genuine statement of priorities, made not by any single villain, but by more than a century of English lawmakers, each one voting, piece by piece, to protect property with the harshest tool available, while leaving personal liberty, especially the personal liberty of poor women, considerably less defended. The prosecution's case needed more than Canning's own word, and it found it, or manufactured it, in a young woman named Virtue Hall, who was living at or connected with Susanna Wells's house at the time of the investigation. Under questioning, first by local investigators and then formally by Henry Fielding himself, Virtue Hall corroborated a version of Canning's story. She placed Canning at the house. She supported the account of the hayloft. Her testimony was, for the prosecution, exactly what the case needed, an independent witness confirming the alleged victim's own account. What Virtue Hall said afterward, though not until much later in this story, changes how that corroboration should be read. She would eventually tell Sir Crisp Gascoyne, the Lord Mayor of London, in a formal statement, that her initial testimony had not been freely given. In her own words, "When I was at Mr. Fielding's, I at first spoke the truth, but was told it was not the truth. I was terrified and threatened to be sent to Newgate and prosecuted as a felon, unless I should speak the truth." Read that sentence again, because it is doing an enormous amount of work. Virtue Hall is saying, on the record, that she initially told investigators something other than what they wanted to hear, and that she only produced the corroborating account they needed after being threatened with prosecution herself if she did not. If that statement is accurate, it means the single piece of independent evidence supporting Elizabeth Canning's story, the one witness whose word did not depend entirely on Canning's own credibility, was obtained under duress from a frightened young woman with every incentive in the world to tell investigators exactly what they wanted to hear. At the time of the first trial, though, none of that had come out yet. Virtue Hall's testimony stood, uncontradicted, exactly as intended, and it helped seal the case against Mary Squires and Susanna Wells before either woman ever stood in front of a jury. The trial opened at the Old Bailey on the 21st of February, 1753, less than a month after Elizabeth Canning had reappeared at her mother's door. Susanna Wells was tried for harboring and comforting a person she knew to have committed a felony, a lesser charge that reflected her role as the keeper of the house rather than the alleged direct perpetrator of the theft. Mary Squires stood accused of the theft itself, the taking of Elizabeth Canning's stays, valued at approximately 10 shillings, by force and threat. The evidence against them was, in essence, Elizabeth Canning's own detailed account, corroborated by Virtue Hall's testimony, weighed against Squires's and Wells's flat denials, and whatever character evidence their side could muster on short notice. Squires, for her part, stated in court, in words that survive in period accounts, that she had never seen the witness in her life until that day 3 weeks prior, a claim that placed the entire case on a direct, irreconcilable collision between two competing accounts of reality. The jury did not need long. Susanna Wells was found guilty of the lesser charge. Mary Squires was found guilty of the theft, and under the sentencing law that made grand larceny above the relevant value a capital offense, she was sentenced to hang. Wells's sentence, branding on the hand, and 6 months' imprisonment, was the standard mark of what English law called benefit of clergy, a legal mechanism that in certain circumstances allowed a lesser felony to be punished short of death. Squires received no such mercy. Her conviction was for the full offense, at the full value, and English law in 1753 did not treat an elderly woman's age or the thinness of the evidence against her as grounds for leniency once a jury had returned its verdict. Within 3 weeks of Elizabeth Canning's reappearance, in other words, a woman was under sentence of death on the word of a servant girl nobody outside her own household had ever laid eyes on before the 29th of January. Picture the room itself for a moment, because the Old Bailey of 1753 was not the closed, formal courtroom a modern viewer might imagine. Justice Hall, as it was known, was substantially open to the outside air and to the public, packed with spectators who came, quite openly, for entertainment as much as for civic duty. Trials moved fast, often several in a single day, decided on a volume and pace of testimony that would look almost reckless by modern standards. There was no presumption, built into the culture of the room, that a case this serious required extended deliberation. The system was built for speed, and speed is exactly what Mary Squires and Susanna Wells received. The defense case for both women rested heavily on flat denial, since neither had, at this early stage, assembled anything resembling the extensive Dorset alibi that would eventually reach the courtroom a year later. A butler connected to the Goldsmiths Company, a man named Nash, is recorded among the early skeptical voices, disputing elements of Canning's description of the room at Enfield Wash, even before Gascoyne's formal investigation began, a small early crack that the fast-moving trial simply did not have time to fully explore. Susanna Wells, for her part, denied ever having laid eyes on Elizabeth Canning before the posse arrived at her door. Mary Squires denied it just as flatly, testifying that she had never seen the witness in her lifetime until that day 3 weeks prior. Against those denials stood Canning's detailed, consistent account, and Virtue Hall's corroboration, not yet exposed as coerced, and a jury that, by every surviving account, took very little time to reach its verdict. It is worth remembering, sitting in that packed, open-air courtroom in your imagination for a moment, that everyone present, judge, jury, spectators, and the 2 accused women themselves, understood exactly what a guilty verdict against Mary Squires would mean. Not imprisonment, not transportation, a rope, and a public execution, likely within days of sentencing. The jury delivered that verdict anyway, on the strength of one servant girl's testimony and one coerced corroboration, inside a single day's proceedings. Contrast that speed against the 7 full sessions it would eventually take, a year later, to try Canning herself for the same fundamental question, whether her word could be trusted, and the difference in how carefully the system treated the 2 cases becomes almost impossible to ignore. The Old Bailey itself, the physical building where both of Elizabeth Canning's cases would eventually be decided, sat immediately beside Newgate Prison, connected closely enough that prisoners could be moved between the 2 with minimal exposure to the street. This proximity was deliberate, a practical arrangement that also carried an unmistakable symbolic weight. Justice and punishment sitting next door to each other, close enough that a convicted prisoner might walk from sentencing to condemned cell in a matter of minutes. Sessions at the Old Bailey ran on what modern observers would consider a genuinely startling schedule. Entire batches of unrelated criminal cases, felonies, misdemeanors, capital charges, and minor thefts, heard back-to-back across a handful of session days scheduled several times a year. A single sitting could dispose of dozens of cases, with individual trials, particularly for straightforward property offenses, sometimes concluded in well under an hour, from opening statement to verdict. Measured against that ordinary pace, the single day devoted to Squires and Wells in February of 1753 was not unusually rushed by the standards of the court. It was the following year's 7-session marathon for Canning herself that was the genuine anomaly, a visible structural sign of just how differently the system was prepared to treat the second trial. Almost immediately, before the ink on the verdict was even fully dry in the public mind, cracks began to show in the version of events that had just sent Mary Squires to the gallows. Investigators and skeptics who examined the actual room at Enfield Wash, the hayloft Canning had described in such specific detail, found things that did not match her account. Where she had described a fireplace and a grate, some who inspected the space afterward reported finding neither. Where she had described a window she had personally forced open to escape, those who examined it found boards that appeared, by their own account, to have been fastened quite recently, not torn loose in a desperate escape. There was a substantial quantity of hay in the loft, roughly half a cartload by one contemporary estimate, hardly consistent with a room deliberately emptied to imprison someone. No footprints were found beneath the window she claimed to have climbed out of, though heavy rain in the days that followed her escape offered at least a partial explanation for that particular gap. None of these details, on their own, proved anything conclusively. Physical scenes get disturbed. Memories under trauma get distorted. Rain washes away evidence that might otherwise have settled the question cleanly. But taken together, they were enough to start a second current running underneath the case, quiet at first, that the story London had believed so completely in the first days of February might not survive close examination. That second current was about to find a very powerful and very unlikely champion, in the person of the Lord Mayor of London himself. Look closer at the specific physical details investigators argued over, because the granularity of the dispute is itself revealing. Canning's hat and comb, recovered as part of her account of the attack, were found cut or hacked by more than one contemporary description, but notably without significant bloodstaining. To skeptics, this suggested the items had been deliberately damaged after the fact, staged evidence rather than the genuine wreckage of a violent struggle, since a real assault severe enough to leave visible cuts would typically be expected to leave blood as well. A band or ribbon found around her neck, by contrast, was described as bloodied, a detail that cut the other way, offering at least some physical corroboration of violence done to her body, whatever its exact cause. The question of whether a person could physically survive 28 days on the rations Canning described, a quartern loaf of bread in total, and water from a single pitcher, occupied real attention at both trials. An apothecary called to testify offered the opinion that survival on such a diet, while severe, was not physically impossible over that time frame. Skeptics pointed instead to the speed of her apparent recovery, noting that a woman described as emaciated, and, in Fielding's own words, so like a specter that her mother fainted at the sight of her, on the night of the 29th of January, was reportedly looking, in the words of one contemporary account, red and white like other people again within a matter of days, a recovery speed that struck several observers as difficult to reconcile with genuine, prolonged starvation. None of these individual details settle the case on their own. Bloodstains fade unpredictably. Recovery times vary by constitution. A staged piece of evidence, and a genuinely traumatic but imperfectly documented one, can look remarkably similar 3 centuries later, filtered through second-hand testimony and hostile cross-examination. What the accumulation of these small, granular disputes does show is how seriously both sides were prepared to fight over every available inch of physical evidence, because both sides understood exactly what was riding on the outcome: first a woman's life, and later a woman's freedom. It is worth noting, with the hindsight of 270 years, exactly what kind of institutional gap the Canning case exposed in the system Henry Fielding himself was trying to build. His work at Bow Street was, at its core, an attempt to replace ad hoc, amateur investigation, exactly the kind of posse led by a local tradesman that first located the house at Enfield Wash, with something more systematic, more professional, more skeptical of a single compelling witness. And yet the most famous case of his own career became a demonstration of precisely the failure mode his reforms were meant to prevent: a powerful, sympathetic narrative, endorsed early by a respected authority figure, hardened into settled fact before anyone had the tools or the institutional patience to test it properly. Fielding did not live to fully reckon with that irony in his own writing. History has had to do it for him. Hold on to the fact this case never lets go of. Kidnapping Elizabeth Canning, if it happened at all, was not something English law in 1753 treated as a serious crime. Stealing 10 shillings worth of her clothing was a hanging offense. A woman was already under sentence of death because of that gap. What happens next is the story of one man trying to close it after the fact, at enormous personal cost. Sir Crisp Gascoyne, the Lord Mayor of London, had presided over the trial that convicted Mary Squires and Susanna Wells. He was not, by training or temperament, a natural ally for a woman most of London had already decided was a criminal gypsy who deserved exactly what the court had given her. And yet, in the weeks after the verdict, Gascoyne became convinced something had gone badly wrong. He began, on his own initiative and largely at his own expense, to investigate Mary Squires' whereabouts during the exact weeks Elizabeth Canning claimed she had been held captive at Enfield Wash. What he found troubled him enough to risk his own considerable public standing on it. Witnesses in Dorset, more than 100 miles from London, were prepared to swear that Mary Squires had been nowhere near Enfield Wash during the period in question. She had been, they said, in and around the village of Abbotsbury, going about the ordinary business of an itinerant trader, selling goods and telling fortunes. The entire time Elizabeth Canning said she was locked in a hayloft, cutting her stays away with a knife. For a man in Gascoyne's position, this was not a comfortable discovery. He had presided over the conviction. He had, by extension, presided over a death sentence against a woman who might, if these Dorset witnesses were telling the truth, have been more than 100 miles from the scene of the crime she was hanged for. That is not a small administrative error to correct quietly. That is the kind of mistake that destroys careers and, in this case, very nearly destroyed his. He pursued it anyway. What Gascoyne assembled over the following weeks was not a single convenient alibi witness easily dismissed as biased or bought. It was, by the account later compiled from his investigation, something closer to 36 separate people willing to testify, under oath if necessary, that they had seen Mary Squires in Dorset and the surrounding counties during the exact window of her alleged crime. The names that survive in the record give some sense of how varied and how ordinary these witnesses were. A man named John Gibbons testified to seeing squires selling goods in Abbotsbury in the first days of January. William Clark corroborated him. A man named Thomas Greville stated that the squire's family had stayed with him at a place called Coombe on the 14th of January, a date that placed them firmly in Dorset, not Enfield Wash, at the exact moment Canning's account required Mary Squires to be standing over her with a knife. Beyond these named witnesses, the broader alibi drew in dozens more ordinary residents of the area: an innkeeper, a clockmaker, laborers, and tradesmen, with no obvious stake in the outcome beyond having seen an elderly Romani woman passing through their part of the country in the normal course of her trade. 6 men reportedly walked 20 miles, on foot, to sign an affidavit on Squires's behalf, an extraordinary personal investment of time and effort for people who stood to gain nothing at all from the outcome, except, perhaps, the simple conviction that they had seen what they had seen and were not willing to let a woman hang for a crime committed somewhere she could not possibly have been. This is worth pausing on, because it is easy, watching a case unfold from 270 years' distance, to treat historical testimony as an abstraction. These were real people, giving up real days of labor, walking real miles, to put their names on a document that might save a stranger's life. Whatever else is uncertain about this case, the scale and the ordinariness of the Dorset alibi is one of its most striking features. This was not one convenient witness. It was dozens. There is one more complicating factor buried inside the timeline of this case, small enough that most retellings skip past it entirely, but genuinely significant to how confused the surviving testimony can be. In September of 1752, only a few months before Elizabeth Canning disappeared, Britain had switched its calendar, moving from the old Julian system to the Gregorian calendar already in use across most of Catholic Europe. The switch required simply deleting 11 days from the calendar outright. The 3rd of September that year was, by official decree, immediately followed by the 14th. For witnesses trying to reconstruct, more than a year later, exactly which days in December of 1752 and January of 1753 they had seen Mary Squires in Dorset, this recent calendar shift was a genuine source of confusion, not a convenient excuse invented after the fact. People who had spent their entire lives reckoning dates one way were now being asked, under oath, in a high-stakes criminal trial, to place specific events against a newly adjusted calendar many of them had not fully internalized yet. It is a small, almost bureaucratic footnote to a case built on dramatic accusations and gallows sentences, and it is also exactly the kind of quiet, structural confusion that can make 2 honest witnesses disagree about a date without either one of them lying. Armed with that evidence, Sir Crisp Gascoyne pursued a royal pardon for Mary Squires, and on the 30th of May, 1753, King George II granted it. The woman sentenced to hang for stealing Elizabeth Canning's stays would not, in the end, be executed. The cost to Gascoyne personally was immediate and severe. London, or at least the substantial portion of it that had thrown itself behind Elizabeth Canning as a wronged innocent, did not receive the news as an act of justice corrected. They received it as an insult, a betrayal by their own Lord Mayor of a girl the city had taken to its heart. Mob violence followed. Gascoyne's coach windows were reportedly smashed. His life was threatened. He would go on to lose a subsequent bid for Parliament, coming, by his own later account, bottom of the poll, a direct and public political price for having pursued a pardon he believed the evidence demanded. He published his own account of his reasoning, an address to the liverymen of the City of London, defending his conduct point by point, laying out the Dorset evidence as he had gathered it, and explaining exactly why he no longer believed the verdict his own court had returned was safe. It is worth noting what Gascoyne did not do, because it says something about the actual limits of his conviction. He secured a pardon for Squires. He did not, at this stage, move to prosecute Elizabeth Canning. That decision, and the machinery behind it, would take considerably longer to assemble, and would require considerably more evidence than a Dorset alibi alone, however extensive. For now, in the summer of 1753, London had an unresolved contradiction sitting directly in the middle of its most talked-about criminal case. A woman had been convicted by a jury, sentenced to death, and then pardoned by the king on the personal intervention of the very official who had presided over her trial. Both things were now simultaneously true in the public record. Nobody had explained how. While the legal machinery ground forward, the human cost accumulated in specific, unglamorous places. Mary Squires and Susanna Wells spent the weeks between their arrest and their trial inside Newgate Prison, one of the most notorious and overcrowded institutions in London, a place contemporary reformers would spend the coming decades campaigning to change, with conditions that killed inmates through disease and neglect nearly as often as any sentence handed down by a judge. Virtue Hall's own detention, first at the Gatehouse Prison in Westminster and later at the Poultry Compter, gives some sense of just how thin the line was, in this period, between witness and suspect. A young woman who had done nothing more than live in the wrong house at the wrong time found herself moved between two separate prisons over the course of the investigation, held under conditions clearly designed to pressure her testimony into the shape investigators needed. The London Daily Advertiser, reporting on the case in February of 1753, described Wells's house at Enfield Wash as the dismal prison, language that tells you plainly which side of the emerging dispute the paper had already taken, months before either trial concluded. Other regional papers picked up the story as it developed. The Derby Mercury reported Susanna Wells's own declaration of her innocence, that she had never seen Elizabeth Canning, faithfully alongside the prosecution's case, a reminder that even at the height of public sympathy for Canning, the accused women's own denials were still being printed and read across the country. Sir Crisp Gascoyne's punishment for pursuing the pardon anyway was not abstract or merely political. Contemporary accounts describe a mob attacking his coach directly, smashing its windows, with his personal safety genuinely threatened in the street, not simply criticized in print. A sitting Lord Mayor of London, one of the most powerful civic offices in the country, found himself physically unsafe in his own city because he had concluded, based on the evidence his own investigation had gathered, that the popular verdict was wrong. Few actions in this entire case demonstrate more starkly just how much genuine, passionate belief London had invested in Elizabeth Canning's account by the summer of 1753, belief strong enough that even the city's own chief magistrate was not safe challenging it. The second blow to the original case against Squires and Wells came from inside the prosecution's own evidence, when Virtue Hall recanted. In a formal statement to Gascoyne, the young woman whose corroborating testimony had helped convict Mary Squires described the circumstances under which that testimony had actually been given. "When I was at Mr. Fielding's," she said, I at first spoke the truth, but was told it was not the truth. I was terrified and threatened to be sent to Newgate and prosecuted as a felon unless I should speak the truth. Strip away the legal language, and what Virtue Hall is describing is coercion. A young woman, held first at the Gatehouse prison and later moved to the Poultry Compter, faced with the threat of prosecution as a felon herself unless she produced the account investigators wanted, ultimately produced that account. Whether her original, uncoerced statement was closer to the truth than the one she gave under threat is impossible to know for certain from the surviving record. What is certain is that the single piece of independent corroboration for Elizabeth Canning's story had just publicly, formally fallen apart. For Henry Fielding, whose entire public reputation was now tied to Elizabeth Canning's credibility, this was a serious problem, and he did not accept it quietly. He continued to defend Canning in print, continued to insist on her fundamental honesty, and continued to describe the case, months after the verdict he had helped secure was already collapsing under scrutiny, in language that left no room for doubt about where he stood. By the second half of 1753, London had split, cleanly and often furiously, into two camps. Those who believed Elizabeth Canning became known, in the language of the day, as Canningites. Those who believed she had fabricated her account, in whole or in significant part, and that Mary Squires and Susanna Wells were the true victims of the affair, were sometimes called Egyptians, using the period's common and prejudiced term for Romani people, or simply Squiresites. This was not an abstract intellectual dispute conducted quietly in learned journals. It was a genuine public fight, conducted through an extraordinary volume of pamphlets, newspaper letters, and public arguments. Public subscriptions raised something in the neighborhood of £300 for Canning's support and legal defense, an enormous sum for the period, drawn from ordinary Londoners who believed her case was a genuine wrong that needed righting. The pamphlet war produced its own minor literature. Henry Fielding continued to write in Canning's defense. On the other side, a physician named John Hill produced a detailed rebuttal, describing Canning's account, in his own words, as a piece of contradictory incidents and most improbable events, a waking dream, the reverie of an idiot. The essayist and portrait painter Allan Ramsay weighed in as well, calling her story not an artful, but on the contrary, an exceeding stupid story, a description meant to suggest that no one clever enough to fabricate a convincing lie would have produced something this riddled with holes, and that its very clumsiness argued, strangely, against deliberate fraud. Even Voltaire, writing from France years later, used the Canning affair as an example in his broader critique of judicial injustice, pairing it in his own writing with the far more famous case of Jean Calas. 2 full years of a great city's public attention, in other words, spent arguing over the fate of a single 18-year-old servant girl and the elderly woman she had accused. It is difficult to overstate how consuming this dispute became, or how personally it was taken by people who had never met either woman and never would. The pamphlet war deserves a closer look than a single summary paragraph can give it, because the sheer volume and specificity of what was published gives you the clearest possible window into how consuming this dispute actually became. On the Canningite side, beyond Henry Fielding's own clear state of the case, supporters produced material with titles like "The Case of Elizabeth Canning Fairly Stated," arguing point by point against every inconsistency her critics had raised, insisting that a traumatized 18-year-old could not reasonably be expected to give a flawless account of the worst month of her life. On the other side, the physician John Hill produced what may be the single most detailed contemporary rebuttal, a pamphlet titled The Story of Elizabeth Canning Considered, walking through the physical evidence at Enfield Wash in forensic detail and concluding, in language that has survived intact, that her account amounted to a piece of contradictory incidents and most improbable events, a waking dream, the reverie of an idiot. Hill was particularly withering about Virtue Hall's original corroboration, noting that she had resisted what he described as 6 hours of strong solicitation before finally producing the statement investigators wanted, specifically because, in his account, she was else to be prosecuted as a felon. The essayist and portrait painter Allan Ramsay weighed in with his own pamphlet, arguing, almost paradoxically, that the clumsiness of Canning's story was itself evidence against her, since a deliberate fraud, clever enough to fool half of London, would surely have been constructed more carefully. "It is not an artful," he wrote, "but on the contrary, an exceeding stupid story," meaning, in effect, that only a genuinely confused or damaged witness, not a calculating liar, could have produced something riddled with quite so many holes. Even satire got involved. An anonymous pamphlet titled The Chronicle of the Canningites and Gipsyites appeared in 1754, written in a deliberately archaic, mock-biblical style, chronicling what it called their direful wars and confusions in courts, a clear sign that by this point the dispute had become not just a legal controversy, but a genuine object of public entertainment and mockery, something London joked about, even as it argued furiously over the fate of 2 real women. The financial dimension of Canning's support tells its own story. Public subscriptions on her behalf reportedly raised something in the neighborhood of £300, an enormous sum for ordinary Londoners to have contributed voluntarily, equivalent by some rough modern estimates to tens of thousands of pounds in today's money. That is not the kind of money a city raises for a cause it finds merely interesting. It is the kind of money a city raises for a cause it has decided, emotionally and morally, it cannot walk away from. Years later, writing from France, Voltaire folded the Canning case into his own broader critique of judicial injustice across Europe, pairing it, in a published account, with the far more infamous case of Jean Calas, a French Protestant wrongly executed for the alleged murder of his own son. That an English servant girl's domestic legal dispute reached the attention of one of the most famous writers in Europe, discussed in the same breath as a case that would eventually help reshape French criminal procedure, gives some sense of just how far beyond London's own gossip networks this story eventually traveled. The regional press, watching from outside London's most heated inner circles, captured the sheer duration and stubbornness of the public dispute better than almost any single pamphlet did. The Manchester Mercury, reporting more than a year after Canning's original return, described the case as still debated with great warmth by her advocates and opponents, a plain acknowledgement that this was not a controversy London had resolved and moved on from, but one that remained genuinely, actively contested well into 1754. Decades later, looking back with the comfortable distance history affords, one retrospective account in the Nottinghamshire Guardian summarized the skeptical verdict that had, by then, come to dominate popular memory of the case, describing Canning's original story as a wild dream, rather than a real fact. That later, settled skepticism is worth noting precisely because it was not universal or even dominant at the time. In 1753, half of London would have argued with that sentence passionately. By the time it was printed, the passage of years had done what neither trial ever quite managed, quietly convincing much of the public which side they now preferred to believe, even without any new evidence to justify the shift. There is a deeper question sitting underneath this entire case, one that later scholars would spend considerable effort trying to answer directly. Why was anyone's word believed at all, in a system with no forensic science, no reliable way to corroborate a claim beyond other people's testimony? The answer, historians of 18th century law have argued, has everything to do with class. The historian Douglas Hay, studying the criminal law of this period broadly, observed that character witnesses carried extraordinary weight in courts like the Old Bailey, and that, in his own phrase, the word of a man of property had the greatest weight of all. Credibility, in other words, was not distributed evenly. It tracked wealth, respectability, and social standing almost as closely as it tracked the actual content of what a witness said. Apply that lens to this case, and the pattern becomes stark. Elizabeth Canning, a servant girl with no property and no independent standing, was nonetheless believed almost instantly, in part because Henry Fielding, a man whose own social and professional standing was considerable, vouched for her. Mary Squires, an elderly Romani woman, existing entirely outside the structures of settled, propertied respectability, that English law implicitly rewarded with credibility, started every single proceeding already several steps behind, regardless of the facts. Virtue Hall, another servant with no independent standing of her own, was leaned on hard enough to produce whatever testimony investigators needed, precisely because her word, on its own, carried so little institutional weight that threatening her with prosecution was sufficient to reshape it. The scholar Christina Straub, examining the specific sexual and social politics surrounding domestic servants in this period, has argued that female servants like Canning occupied an especially precarious position in the public imagination, treated simultaneously as potential victims deserving of sympathy and as inherently suspect figures whose sexual conduct and honesty were always open to question by the households that employed them. That double bind, sympathetic victim on one hand, suspect liar on the other, sits at the exact center of why London split so completely into Canningites and Egyptians. Both readings of Elizabeth Canning were, in the cultural logic of the period, always available at once. None of this proves what actually happened to Elizabeth Canning during those 28 days. What it does show is that the legal system asked to determine the truth was never a neutral instrument simply weighing evidence. It was a system already carrying deep, built-in assumptions about whose word counted and how much before a single witness ever took the stand. Somewhere in the middle of this pamphlet war, the machinery that had convicted Mary Squires began, slowly and deliberately, to turn back around toward the woman who had accused her. If Squires's Dorset alibi was genuine, if she truly had been more than 100 miles from Enfield Wash during the entire period Canning claimed to have been imprisoned there, then Canning's sworn testimony, the deposition she had given Henry Fielding under oath on the 7th of February, was not simply mistaken. It was, in the strict legal sense, perjury. A false statement made under oath in a judicial proceeding, and in a case where that statement had directly resulted in a death sentence against an innocent person. It was about as serious a version of that crime as English law recognized. The exact timeline of Canning's own indictment is one of the murkier corners of this case. Different contemporary and later sources place her formal arrest or indictment at various points across 1753, ranging from the spring through the autumn, and the surviving record does not allow for perfect precision on the exact date. What is certain is this. The gap between Elizabeth Canning's return in January of 1753 and the opening of her own trial was well over a year, a period during which London's public argument over her credibility only grew louder and more entrenched, and during which the evidence Gascoyne had assembled had time to be tested, challenged, and refined by lawyers on both sides. When that trial finally opened, it would not be a quick affair, nothing like the single day that had been sufficient to convict Mary Squires. It would become one of the longest criminal trials London had ever seen, and its length alone tells you something about just how unresolved this case remained, even after a year and a half of public argument. The fact this case never lets go of is about to turn on the person who first stated it. Kidnapping was not a crime. Theft of her stays was a hanging offense. Mary Squires had already been sentenced to death and then pardoned on that distinction. Now the same court was about to ask whether the girl who first drew that distinction into a courtroom had been lying the whole time. Elizabeth Canning's trial for willful and corrupt perjury opened at the Old Bailey on Monday the 29th of April, 1754. It did not resemble anything about the trial that had convicted Mary Squires 14 months earlier. Where that first trial had been resolved inside a single day, Canning's own proceedings stretched across 7 separate sessions, held on the 29th of April, the 1st, 3rd, 4th, 6th, 7th, and 8th of May, an arrangement almost unheard of for a criminal trial of the period. London's courts were not built for cases that took a week and a half to hear. The fact that this one did tells you, more clearly than any pamphlet could, just how much conflicting testimony both sides now had to present, and how seriously the court itself was treating the question of whether a woman who had once been treated as an innocent victim deserved to be convicted of the very crime, false swearing, that had sent someone else to the gallows. The defense's central weapon was the same Dorset alibi Gascoyne had assembled the year before, now presented in far greater depth and with far more witnesses than had been available at the original trial. Roughly 36 residents of Dorset and the surrounding counties took the stand or gave sworn statements placing Mary Squires firmly away from London during the entire period in question. The prosecution, for its part, worked to undermine that alibi, questioning the reliability and possible coordination of witnesses testifying more than a year after the events in question, and continuing to press the physical inconsistencies in the Enfield Wash house itself, the fireplace that may not have existed, the window boards that appeared freshly fastened rather than freshly broken, the sheer quantity of undisturbed hay in a room supposedly emptied to hold a prisoner. Fortunatus and his wife Judith, who had lived in or around the Wells property, testified that they had occupied the very hayloft Canning described continuously through a roughly 12-week period spanning January of 1753, a direct and specific contradiction of Canning's claim that the room had been used to imprison her, alone, for the entire month. 2 competing versions of reality, each supported by real witnesses swearing real oaths, sat directly across from each other in that courtroom for a week and a half. Nobody watching the proceedings in real time could have told you, with any confidence, which version the jury was going to believe. The bench presiding over Canning's 7-session trial in the spring of 1754 carried real institutional weight. Thomas Rawlinson, Gascoyne's successor as Lord Mayor, presided nominally over the proceedings, joined on the bench by Justice Edward Clive of the Common Pleas, Baron Heneage's Leg of the Exchequer, the Recorder of London William Morton, and Alderman Samuel Fludier. This was not a minor magistrates' court hastily assembled. It was a significant portion of London's senior judiciary, gathered specifically because the case had become too consequential and too publicly contested to be settled by anyone less. One detail from the legal teams involved is worth sitting with on its own. William Davey, who had served as defense counsel for Mary Squires and Susanna Wells at their original trial in February of 1753, appears among the prosecution at Canning's perjury trial the following year, now arguing in effect the opposite side of the same underlying dispute he had once fought from the defense table. Legal careers of the period frequently involved this kind of role switching from case to case. But the symmetry here is difficult to ignore. The same courtroom, the same underlying facts, and at least one of the same lawyers, now arguing that the witness whose testimony he had once tried and failed to discredit had in fact been lying all along. Canning's own defense was handled by George Nares and John Morton, tasked with the considerably harder job of defending a woman whose central accuser, in a strange inversion, was now the machinery of the state itself, represented by prosecutors including Edward Wills and Crisp Gascoyne, men working to prove that the very testimony a court had accepted as sufficient to nearly hang someone a year earlier had, in fact, been a deliberate fabrication. The Dorset alibi witnesses who appeared across those 7 sessions, numbered in the dozens by this second trial, considerably more thorough than what Gascoyne had first assembled. Beyond the previously named John Gibbons, William Clark, and Thomas Greville, the surviving record preserves names like Mrs. Hopkins, who kept an inn at South Parrot and testified to Squires's presence there, Alice Farnham, Loomworth Dane, a clockmaker named Samuel Story, William Headland, and James Pratt, an unremarkable list of tradespeople, innkeepers, and laborers whose only real distinction was having happened to see an elderly itinerant woman passing through their part of Dorset during a specific handful of January days, and having been willing, more than a year later, to travel to London and swear to it under oath. Reverend James Harris, an Anglican clergyman at Abbotsbury, lent his own testimony and standing to the same alibi, a detail that would have carried particular weight with a jury inclined to trust the word of a clergyman over that of an itinerant Romani family. Weigh that against the core of the prosecution's case against Canning herself, which rested, in the end, on the same fundamental physical inconsistencies first noticed back in February of 1753, the missing fireplace, the freshly fastened window boards, the undisturbed quantity of hay, the Natus family's continuous occupation of the loft. No new confession, no new physical proof, just, on one side, dozens of ordinary witnesses placing an old woman somewhere else entirely, and on the other, one traumatized girl's account of an experience nobody but her had actually witnessed. It is worth walking through those 7 sessions individually, because the shape of the trial, stretched across a week and a half, rather than compressed into a single day, tells its own story about how genuinely undecided this case remained, even after a year of public argument. Monday, the 29th of April, opened the proceedings, with the formal reading of the indictment and the prosecution laying out its central claim, that Elizabeth Canning had willfully and corruptly sworn a false account against Mary Squires, an account that had already cost Squires a death sentence before it was reversed by royal pardon. Wednesday, the 1st of May, and Friday, the 3rd of May, were consumed largely by the parade of Dorset and Wiltshire witnesses, the alibi Sir Crisp Gascoyne had first assembled the year before, now presented in far greater depth. Name after name took the stand. Ordinary tradespeople and laborers, with no evident stake in the outcome, each one placing Mary Squires somewhere between Abbotsbury and the surrounding Dorset countryside during the exact days Canning's account required her to be at Enfield Wash. Saturday, the 4th of May, and Monday, the 6th of May, turned to the physical evidence from the house itself and to the testimony of Fortune and Judith Natus, who described their own extended occupation of the hayloft Canning, claimed to have been locked inside, a direct contradiction that the prosecution worked hard, across these 2 sessions, to undermine on grounds of memory and possible coordination with the defense. Tuesday, the 7th of May, brought closing arguments from both sides, each attorney summarizing a case that, after 6 full days of testimony, still had not resolved into anything like an obvious conclusion. And on Wednesday, the 8th of May, the jury finally received their instructions and retired to consider a verdict that, when it came 2 days later on the 30th, would itself prove to be anything but simple. 7 sessions, more than a week of a London court's attention, dedicated entirely to determining whether one servant girl's account of the worst month of her life had been an honest, if imperfect, description of real events, or a deliberate, deadly fabrication. No criminal trial of the period, outside the handful of great state treason cases, had commanded anything close to this much sustained judicial time. That fact alone tells you something the verdict itself never quite managed to settle. Nobody involved, not the prosecution, not the defense, not the judges presiding, treated this as an easy question. When the jury finally returned, on the 30th of May, 1754, they did not deliver a clean verdict. Their first answer was that Elizabeth Canning was guilty of perjury, but not willful and corrupt perjury, a distinction with enormous legal consequences buried inside what sounds, on the surface, like a minor technical qualification. Perjury alone, without the specific finding of willful and corrupt intent, was a considerably lesser offense, one that would not have supported the severe sentence the prosecution was seeking. The Recorder of London, presiding over the sentencing phase, refused to accept that verdict as it stood. He sent the jury back to reconsider, with instructions that made clear a partial or hedged finding was not going to be accepted as final. The charge, as he characterized it to them, was one of the most heinous crimes imaginable, an endeavor, through willful and corrupt forswearing of herself, to take away the life of a guiltless person. The jury deliberated for roughly 20 more minutes. When they returned this time, the verdict had hardened, guilty of willful and corrupt perjury. The distinction the jury had initially tried to preserve, some meaningful gap between an honest mistake and a deliberate lie, had been closed, whether because the jurors themselves came to a firmer view of the evidence in those 20 minutes, or because they understood that a softer verdict was simply not going to be accepted by the court presiding over them. It is worth noting that at least 2 jurors reportedly signed affidavits afterward, stating they had never intended to find Canning guilty of the willful and corrupt element specifically, only of the lesser, softer version of the offense their first verdict had tried to record. If that account is accurate, it means the final, official verdict against Elizabeth Canning may not have fully reflected what at least some of her own jury actually believed about her intentions, even at the moment they returned it. The specific legal phrase at the center of Canning's conviction, willful and corrupt perjury, is worth unpacking, because the distinction the jury initially tried to preserve in their first, rejected verdict was not a minor technicality. It went to the very heart of what kind of person the court was being asked to punish. Simple perjury, in the legal thinking of the period, could describe a false statement made under oath through genuine error, confusion, or honest mistaken belief. Still a serious matter, but categorically different from a lie told knowingly, with the specific intent to deceive the court and cause harm to another person. Willful and corrupt perjury required proof, or at least a jury's conviction of that deliberate intent. It was, in effect, asking the jury not simply whether Canning's testimony had been factually wrong, but whether she had known it was wrong at the moment she swore to it. That is an extraordinarily difficult thing to prove about another human being's internal state, particularly one who may have been suffering some form of genuine psychological trauma that even she herself did not fully understand. When the jury's first answer split the difference, guilty of perjury, but not willful and corrupt, they were, arguably, expressing exactly that difficulty, a belief that her testimony had been factually wrong without a corresponding confidence that she had lied about it on purpose. The recorder's refusal to accept that verdict, and the harder finding that followed 20 minutes later, effectively collapsed a meaningful, honest distinction the jury itself had first tried to preserve. The sentence, handed down the same day, the 30th of May, 1754, was 1 month's imprisonment, followed by 7 years' transportation, banishment from England to a penal colony, in this case, ultimately, the American colonies, for the full term of her sentence. What makes this sentence particularly striking is how it was reached. By the surviving accounts, the specific punishment was decided by a vote among the judges or aldermen determining the sentence, and that vote split 9-8, a single vote. The margin between Elizabeth Canning serving 7 years an ocean away from everyone she had ever known, and some lesser outcome the record does not fully specify, but which most historians assume would have involved corporal punishment, the pillory or public whipping, more typically associated with a perjury conviction of this era, came down to one person in a room changing their mind, or simply being persuadable in a direction their colleague was not. Consider what that means. This was not an overwhelming, unambiguous judgment handed down by a court fully convinced of Elizabeth Canning's guilt and united on the appropriate punishment for it. It was a narrow, contested decision, arrived at after a trial that had already taken a week and a half, specifically because the evidence refused to resolve itself cleanly, decided in the end by a margin of a single vote among the men empowered to decide it. 270 years later, that 9-8 vote remains one of the most quietly devastating facts in the entire case. It is easy, watching history from a comfortable distance, to imagine verdicts as settled, obvious conclusions reached by people who simply understood the facts better than we can from here. The reality, in Elizabeth Canning's case, is that the people who actually heard every witness, examined every alibi, and sat through 7 full sessions of testimony still could not agree. They split almost exactly down the middle, and the side that happened to have one more vote decided that a 19-year-old woman would cross an ocean for it. Transportation, as a sentence, meant something specific and something genuinely brutal in 18th century English law. It meant forced removal from England, under guard, aboard a ship bound for a penal colony, most commonly at this period one of Britain's American colonies, followed by a period of indentured servitude, effectively unpaid labor under a colonial master, for the full length of the sentence. For Elizabeth Canning, that sentence meant 7 years. The exact date of her departure is not perfectly settled in the surviving record, with sources placing it either at the end of July or more broadly across August of 1754. But what is certain is that sometime in the summer of that year, she was placed aboard a ship and carried across the Atlantic, away from her mother, away from the city that had spent 2 years arguing furiously over whether she deserved sympathy or punishment, and away from England for what her sentence specified as 7 full years. She landed in the American colonies and eventually settled in Wethersfield, Connecticut, where she came under the protection of the family of the Reverend Elisha Williams, a former rector of Yale College. Whatever reputation had followed her across the ocean, it did not prevent her from building something close to an ordinary life in her new country. On the 24th of November, 1756, she married a man named John Treat, connected to the family of a former colonial governor of Connecticut. She had children. The exact number and their names are not fully consistent across the surviving genealogical record, but at least one son, born in the summer of 1758, and at least one daughter, born several years later, are attested. Sit with the shape of that. A girl who left England in disgrace, convicted by a narrow, contested vote of deliberately sending an innocent woman to the gallows, crossed an ocean under sentence, and within 2 years had married into a prominent local family in her new home and begun raising children of her own. Whatever the truth of what happened to her in 1753, whatever the jury actually believed in that 20-minute recess before they hardened their verdict, Elizabeth Canning did not spend the rest of her life as a convicted perjurer in the eyes of the community she actually lived among. She spent it, by every surviving account, as a wife, a mother, and a respected member of a Connecticut town that either never fully learned the details of the scandal she had left behind her, or chose not to hold them against her. Before we close, it is worth understanding what the physical experience of Elizabeth Canning's sentence actually involved, because 7 years transportation is easy to say as a phrase, and considerably harder to sit with as a lived reality. Convict transport ships of this period were, by nearly every surviving account of the broader system, brutal environments. Passengers, many of them already weakened by time spent in prison awaiting transport, were packed into confined quarters below deck for a crossing that could run anywhere from 6 to 10 weeks, depending on weather and route, with disease, poor food, and inadequate water-regular features of the voyage. Mortality on convict transport crossings of this era was not a rare exception. It was a routine, accepted cost of the system, one more piece of the sentence that the courtroom record never has to spell out explicitly, because everyone involved already understood it. Elizabeth Canning survived that crossing, arriving in the American colonies sometime in the summer of 1754, and made her way, or was directed, to Wethersfield, Connecticut, a well-established colonial town on the Connecticut River. That she came under the protection of the family of the Reverend Elisha Williams, a former rector of Yale College, suggests either a genuinely fortunate placement or a deliberate effort by sympathizers, possibly connected to the considerable Canningite fundraising back in London, to see her land somewhere safe rather than simply auctioned into indentured labor with whoever happened to be buying convict service that week, which was the more typical fate of transported prisoners, with no connections waiting for them on arrival. 2 years after her arrival, on the 24th of November, 1756, she married John Treat, a member of a family connected to a former colonial governor of Connecticut, a genuinely respectable local match for a woman who had left England only 2 years earlier under a criminal sentence for perjury. Whatever reputation crossed the Atlantic with her, it evidently did not prevent a prominent local family from accepting her into their own. Consider the distance, not just in miles but in social terms, between the 18-year-old girl who stumbled bleeding into her mother's house in Aldermanbury Postern in January of 1753 and the young married woman building a household in a prosperous Connecticut river town less than 4 years later. Whatever the truth buried inside those 28 missing days, Elizabeth Canning did not let the verdict against her define the rest of her life. She built something else entirely, on the other side of an ocean, among people who either never learned the full shape of the scandal she had survived, or judged her by the woman standing in front of them, rather than the newspaper reports that had once made her the most argued about servant girl in England. One fact carried this entire case from a servant girl's doorstep to a Connecticut grave. In 1753, kidnapping a grown woman was not, on its own, a crime English law took seriously. Stealing 10 shillings worth of her clothing was a hanging offense. A stranger was sentenced to die because of that gap, then pardoned. The girl who opened that gap was sentenced herself by a single vote and shipped across an ocean for it. Here, finally, is what became of everyone left standing when the courtroom doors closed for the last time. Every person at the center of this case ended up somewhere different, and none of those endings quite settle the question the whole story was actually about. Mary Squires, the woman sentenced to hang for a corset and then pardoned by the king himself, lived on after her pardon, though the precise date and circumstances of her later life and death are not reliably established in the surviving record. And this is a case where it is more honest to say so plainly than to repeat a single unverified date as though it were settled fact. What is certain is that she died, still carrying, in the eyes of a significant portion of London, the suspicion that had put a rope around her neck in the first place. A royal pardon clears a legal record. It does not always clear a reputation. Susanna Wells completed her sentence. Released from Newgate Prison on the 21st of August, 1753, branded on the hand as the law required, and largely disappears from the historical record after that. An ordinary woman who happened to be standing at the center of an extraordinary controversy for a little over a year, and who spent the rest of her life outside the pages of history entirely. Henry Fielding, the magistrate and novelist who staked so much of his own credibility on Elizabeth Canning's honesty, did not live to see the full resolution of the case he had helped set in motion. He died in October of 1754, only months after Canning's conviction and transportation. His own final assessment of her guilt or innocence never fully revised in writing, as far as the surviving record shows, before his death. Sir Crisp Gascoyne, who paid the steepest immediate political price of anyone involved, having pursued Squires's pardon at the cost of mob violence against his own person and the loss of his subsequent bid for Parliament, did eventually receive a measure of formal vindication. The Common Council of the City of London extended him a vote of thanks at the conclusion of his term as Lord Mayor, an official, institutional acknowledgement that his pursuit of the Dorset alibi, however unpopular it had been with the crowd outside his coach window, had been the correct and honorable use of his office. And Elizabeth Canning built a new life on the other side of an ocean, married, raised children, and died in Wethersfield, Connecticut in 1773 at roughly 38 years old. Different sources give her death in June of that year, others as specifically the 22nd of July, and the surviving record does not allow for full certainty between them. What is certain is that news of her death reached England and was reported in English newspapers. A small, quiet coda confirming that even 20 years later, on another continent, London had not entirely forgotten the servant girl whose testimony once split the city in half. Here is what nobody, in 270 years, has ever managed to resolve. Modern historians and writers have proposed genuinely serious, carefully argued theories on both sides of this case. Some have concluded Elizabeth Canning suffered a form of trauma-induced amnesia, that something genuinely terrible happened to her during those 28 days, something her own mind may not have been able to accurately reconstruct afterward, and that her testimony, however factually inconsistent, represented a sincere, damaged attempt to explain an experience she herself did not fully understand. Others have concluded, with equal seriousness, that the physical evidence, the fireplace that was not there, the window boards fastened rather than broken, the hayloft occupied continuously by other people the entire time she claimed to be locked inside it, simply cannot be reconciled with an honest account, however traumatized the person giving it. Both readings have real evidence behind them. Neither one has ever definitively won. What is not in dispute, what every single person who has studied this case across nearly 3 centuries agrees on completely, is the shape of what the law actually did with the uncertainty. It did not sit with the ambiguity. It did not decline to choose. It took a single 18-year-old girl's account of the worst month of her life and used it to sentence a stranger to hang for stealing a piece of clothing in a country where taking that same girl's freedom by force for 28 days was not, on its own, considered a crime worth the court's full attention. Then, when the story stopped adding up cleanly, that same machinery turned around and used its full weight against the girl who had trusted it in the first place, deciding her fate by a margin of 1 single vote out of 17. Sir Crisp Gascoyne's story did not end with mob violence and a lost parliamentary bid. In the years that followed, as the immediate public fury cooled, his conduct in the Canning affair came to be regarded, by a growing portion of London's political and legal establishment, as a genuine act of civic courage, a Lord Mayor willing to reverse his own court's verdict, at real personal cost, because the evidence demanded it. The formal vote of thanks extended to him by the Common Council at the close of his mayoral term was an early sign of that shift, an institutional acknowledgement, however belated, that pursuing an unpopular truth had been the right use of his office, whatever the mob outside his coach window had believed in the heat of the moment. It is a smaller vindication than a full reversal of public opinion, and it came only after Gascoyne had already paid the steepest part of the price. But it stands, alongside the Dorset alibi he assembled almost single-handedly, as the clearest evidence in the entire case that at least one person with real institutional power was prepared to follow the facts somewhere genuinely uncomfortable, even when an entire city had already decided, loudly and passionately, which answer it wanted. Historians have kept arguing about Elizabeth Canning for a very long time, and the range of serious, carefully researched conclusions they have reached is itself worth walking through, because it shows just how genuinely unresolved this case remains, even under close modern scrutiny. In 1925, the writer Arthur Machen produced a full-length account titled The Canning Wonder, treating the case as one of the great unsolved mysteries of English criminal history, worthy of the same careful narrative attention as any modern true crime investigation. 2 decades later, the writer Lillian de la Torre proposed a specific psychological explanation, arguing that Canning had suffered what she called hysterical amnesia, quoting the psychiatrist Arthur Percy Noyes on the way certain trauma responses can, in his words, obliterate recollections for a definitely circumscribed period. De la Torre's conclusion was, in effect, that Canning never told her secret because she never fully knew what it was herself, that something genuinely traumatic had happened to her, and that her testimony was a sincere, if factually corrupted attempt to make sense of an experience her own mind had partly walled off. The writer John Treherne, in a later study titled The Canning Enigma, took a different path, suggesting Canning had likely been near Enfield Wash for some genuine reason, but had not actually been imprisoned there, and speculating that the specific accusatory details of her story may have been shaped, consciously or not, by the leading questions of investigators like Robert Scarratt and Alderman Chitty during those first, chaotic days of examination. Treherne went so far as to describe Canning as something like the first manufactured media sensation, a real person whose actual experience became steadily overwritten by the expectations and narrative needs of everyone around her. The academic historian Judith Moore, in a 1994 study titled The Appearance of Truth, approached the case from a different angle entirely, focusing on the class and power dynamics running underneath every piece of testimony in the record, and on just how easily a servant class witness like Virtue Hall could be coerced into telling investigators exactly what they needed to hear. Moore's reading leans toward taking Canning's core account seriously, not because the physical evidence is clean, but because the entire apparatus of the investigation was built in a way that made honest, uncoerced testimony from working-class witnesses extremely difficult to obtain in the first place. The Victorian barrister John Paget, writing decades earlier, arrived at perhaps the most quotable summary the case has ever received, calling it, in his own words, in truth, perhaps, the most complete and most inexplicable judicial puzzle on record. Andrew Lang, writing in 1904, reached his own conclusion after an exhaustive retelling of the evidence, stating plainly that in his opinion, Elizabeth Canning was a victim of the common sense of the 18th century, a verdict that shifts the blame away from Canning's own honesty and toward the crude, overconfident investigative instincts of the people around her. The case has even left a mark on English fiction. The novelist Josephine Tey drew loosely on the Canning story for her 1948 novel, The Franchise Affair, transposing the basic shape of the accusation, a young woman's uncorroborated claim of imprisonment against two other women, into a contemporary setting. Tey herself apparently regarded the original historical case with real skepticism, reportedly describing it in her own research notes as a tissue of lies from start to end, even as she used its emotional architecture to build a novel that took the opposite side, sympathizing with the accused rather than the accuser. What you are left with, after 270 years of exactly this kind of careful, serious, professional disagreement, is not a solved case with a stubborn public misconception attached to it. It is a genuinely open one, examined by novelists, psychiatrists, barristers, and academic historians, each bringing real evidence and real expertise to the question, and each one, in the end, landing somewhere different. It is worth asking, before we close, why a case this obscure, buried in a handful of academic studies and out-of-print pamphlets, still has anything to say to anyone watching this 270 years later. The answer sits in exactly the kind of evidence this case was built on, and exactly the kind of evidence modern criminal justice systems have spent the last several decades learning to distrust. Elizabeth Canning's entire account, and the entire case against Mary Squires, rested on eyewitness testimony, a traumatized young woman's memory of a horrifying experience, corroborated by a second witness whose account was, by her own later admission, extracted under threat. Modern research into memory and trauma has demonstrated repeatedly what nobody in 1753 had any real framework for understanding: that genuine trauma can distort memory in ways that have nothing to do with dishonesty, that coerced testimony is inherently unreliable regardless of how confidently it is delivered, and that eyewitness identification, even when sincerely and passionately believed by the witness herself, is one of the least reliable forms of evidence a court can rely on. None of that modern understanding existed for the judges, jurors, and magistrates of 1753 and 1754. They were left instead with only their own instinct for who seemed truthful, an instinct that proved, across 2 full trials and 18 months of investigation, catastrophically unable to produce a verdict anyone could feel fully confident in. 2 centuries of forensic and psychological advancement later, cases built on nothing but sincere, confident testimony still produce wrongful convictions with disturbing regularity. Elizabeth Canning's case is, in that sense, not simply a curious historical footnote. It is an early, unusually well-documented demonstration of a problem the legal system has never fully solved: the gap between how certain a witness sounds and how certain a witness actually is. An old woman was sentenced to hang for a corset. The girl who accused her was tried next. 270 years later, we still do not know, with any real confidence, which of them the truth actually protected. If this is the first time you have heard the name Elizabeth Canning, you are not alone. Almost nobody has. This case does not appear in most general histories of the 18th century. It survives mainly in a handful of academic studies, a few contemporary pamphlets scanned into digital archives, and the occasional footnote in books about Henry Fielding's literary career, where his role as her defender is treated as a minor biographical curiosity rather than the center of the story it deserves to be. That is worth sitting with for a moment before you go. A case that split an entire city in half, that produced a royal pardon, a mob outside the Lord Mayor's coach, a 7-session trial, and a sentence decided by a single vote, has been almost entirely forgotten by everyone except the small number of historians who happen to go looking for it. Somewhere in Wethersfield, Connecticut, there is a grave, and a woman buried in it who crossed an ocean under a sentence for lying about the worst thing that had ever happened to her, or for telling the truth about it and simply not being believed by the people whose job it was to decide. The historical record, honestly examined, cannot tell you with certainty which. Neither, in the end, could the 17 men whose votes decided her fate on the 30th of May, 1754, 9 of them one way, 8 of them the other. That is not a satisfying ending. It is as close as the surviving evidence allows anyone to get, the true one. If you want more cases like this one, the buried ones, the ones where the evidence is complete enough to argue about and never complete enough to settle, subscribe and stay a while. There are a great many trials history forgot to finish. We intend to keep opening them. Elizabeth Canning walked out of her mother's house on New Year's Day, 1753, an ordinary 18-year-old servant girl nobody outside her own small circle had ever heard of. 28 days later, she walked back in, and by the time this story finally stopped moving through English courtrooms, it had cost one woman a death sentence and a pardon, another woman a branding and half a year in prison, a third woman 7 years and an ocean, and a sitting Lord Mayor of London the rest of his political career. Nobody, in the end, was declared innocent. Nobody was declared guilty and left that way. The record simply stopped, the way records sometimes do. In the middle of an argument nobody had finished having. 270 years on, we are still not finished having it either.